Okay, the committee will now hear House Bills 1307 and 1313 coincide with each other, or is that?
Yes, Mr. Chairman, we've got identical bills have been filed.
Sure.
So Chairman thought that we just take them up at the same time. So
That'd be fine. Representative Elmer, you done?
thank you, Mr. Chairman. What we have here, and I'll just take you through the mechanics of the bill real quick, and I'll turn it over to Dr. Frederick. We have a change in the waiting period is between the time that a woman goes in for the examination to obtain an abortion versus when she has the procedure actually completed. Right now, the statute says it's 24 hours. This is a change to extend that to 72 hours. That is what the bill does. We don't touch any of the other things that already exist with regard to the notification and the examination, and those things are already in the statute. So this is just an extension of the waiting period. You'll see there's some additional verbiage that's been added in a couple of sections. Those are what I'd call saving clauses, and it's one of those things where that right now, the way that our sections of the statutes work, they've operated okay, they hold up the constitutional challenge, and this would be one of those things where that in the event that this extension to 72 hours would for some reason be overturned or by the courts or something, it would still provide a fallback, I guess I would say, to the current statute, to where that it would operate as it currently is in the event of that, rather than tossing out the whole statute itself.
Okay,
So,
all right. We'll go ahead, Representative Dr. Frederick, go ahead.
Representative Elmer and I were of like minds and sort of kindred spirits in identifying this as a need to change our current process. And it really comes from my sort of background in healthcare. As you know, I'm an orthopedic surgeon, so I do a lot of elective surgery. I replace knees and hips and make crooked bones straight, And frequently when I see the patient in the office, I would say more often than not, when I first meet them and we identify the fact that they have a badly worn out knee or hip or whatever the joint happens to be, very seldom do we make the decision that day, right there, to proceed with the surgery. Now, in the office case, we're also planning the surgery for, usually the schedule doesn't allow us to get it on for several weeks or maybe more than months. So the patient has that additional time to decide whether to proceed with the surgery or not. But it just strikes me that if in the course of my practice in the last 25 years, I have made it a habit not to make the decision right then, right there, when I first meet the patient and tell them how bad the arthritis is. And I tell them to go home and study this, talk about what we've talked about. We talked about potential risks and benefits and the advantages and disadvantages and the complications and all that. And I tell them to go home and consider that and, whatever resources we provide them, read that and talk with family. Let us know if they have any further questions. And that is for a procedure that has a very high rate of success. There is a small instance of complications, but we want them to really consider those complications and alternatives before they make a decision about surgery on their knee. And it strikes me that the decision to undergo an abortion is at least as important and impactful in the person's life, especially the child, as a surgical decision is. So this does not make it illegal. It doesn't restrict access. It simply says we want additional time to be reflective of all of the information and all of the decision process that is before that person. So with that, I entertain any questions.
Just a comment I'd like to make to you, Dr. Frederick. As you know, some time ago, back in 2009, I was diagnosed with cancer. And I know you know this doctor teaching his father quite well. And at the time when I discussed the outcome of my results, he made the comment to me, he says, I want to tell you this. He said, you have two options. You either go to surgery or you go to radiation. And I'm not here to ask you for an answer today. I'm going to give you a reference book. I want you to go home, I want you to read this. Discuss it with your wife. What you decide is your business. If you have questions, I will get you in touch with a radiologist. By the same token, I do perform surgery, but strictly it is your decision. And he says, what time frame would you like to have? I said, as a doctor teaching, I'd like to have 1 week. I'd like to talk to you again because I will make a decision quickly. He said, that'd be fine. And I felt very much at ease with that, and I appreciate you sharing that with me.
I had no idea that you had had that particular experience, but that exemplifies this exactly as I intended. So
Are there any questions for either one? Yes, Representative Wood.
To inquire,
Yes.
by statute, when you go in for your visit for an abortion, aren't they required to give you a rather large amount of information as to everything under the sun about the abortion? I think we've had testimony in the past where it's a large packet, it goes through all the complications, all the sides, and there's just very little time in 24 hours to really study and devour that. Would you say that's an accurate assumption?
I believe that's correct. I mean, if you just read the statute and it goes through and says, you have to provide this, you have to provide this, you have to provide this. And if you think about each one of those items that are delineated then, and the amount of information that that would be, I mean, it's a pretty brief description what's in the statute, and I believe that you know, there's quite a bit that's there. So I think that it's reasonable to give this mother the opportunity to fully consider what she's been given.
And you're by no means taking away the emergency to where if it's a life-threatening situation that you would have to wait 72 hours.
Right, we've not
nothing there.
touched any other sections of this
Right.
statute. It's simply, you can see where we've deleted the words 24 and added 72, and then that other language that I described was the savings clause. So with regard to this current statute, the real change is just the 24 to 72 hours.
So just taking a little extra time to make an informed decision could harm no one.
Yeah, I mean, the downside would be maybe you'd have another baby or two more.
All right, thank you.
Thank you. Representative Crookton?
Inquire, please.
Yes, proceed.
Thank you.
Good afternoon. This may be more for you, Representative Elmer. The last section, 7, on the last page,
Yes.
it reads that if this part of this act is ever temporarily or permanently restrained or enjoined by judicial order, this section shall be enforced. Can you walk me through how that is based in legal?
Well, what we're looking at is in the first part of that, if you look at the first sentence, we're referring to the newly amended provisions. So that would be the changes. And then when it goes on to say that when we're talking about that section that you say, this section, we're referring to the entire section as it exists now. So we're saying if the newly amended provisions are enjoined by a court, then the remaining parts of the section will still be
Are still
enforced.
enforced, okay. And then I have another question for either one of you. As far as the 72 hours and elective surgery, would it be a good idea for us to enshrine any elective surgery requiring a 72-hour waiting period and all?
I think any elective surgery where the unrepresented infant is at stake should be 72 hours. Now, when you're making a decision solely and only for yourself, I don't think we should enshrine that in law, but I do believe that we are protecting an individual who cannot speak for him or herself.
Thank you.
Okay. Representative Kelly?
Thank you, Mr. Chairman. May I inquire?
Yes.
May I follow up a little bit on Representative Kirkton's question about Section 7? Representative Elmer, I see what you're saying about you don't want the underlying portion of the section to be restrained because the new portion
Correct.
is restrained. Doesn't it work better than to say if any individual section of this section is restrained, it shall not have the effect of restraining the rest of the bill, rather than simply saying the new part? Because some of the old part might be restrained too.
Well,
See what I'm saying?
You're correct, and whenever I read this, I haven't changed it since it was drafted, and I did think about that because that's more typically what you'd see in those saving clauses in typical contracts. So I think that may be an improvement.
The restrained section is restrained, but the rest of the
Yes.
section of law would continue in effect if not restrained.
And we can look at amending this because that may operate better. And like I said, whenever I was reading this, I was like, that could be a possibility.
Thank you, Mr. Chairman.
Thank you. Representative Pace, I believe you are.
Yes, thank you. To inquire, please.
Yes, proceed.
Thank you. I was just looking at some of the information here, and it says that there are 26 states that have a law in effect that requires a woman to wait a waiting period. and then there are only 2 in the state, and that's Utah and South Dakota, that has a waiting period of 72 hours. And I was just wondering, have you done a survey with some women that say that they need this additional time? I mean, when you're pregnant, you're thinking about that prior to, say, the analogy that was given as far as a knee replacement or what have you. You have no idea what's going on with your knee, your hip, or what have you, till you go to the physician for that. But you know when you're pregnant. So 24 hours is not the entire time that you got to think about this, your decision, or make a decision. You're thinking about that on an ongoing basis. So I think, and I don't know if you've done a survey, but I would think that a person that comes in and makes that decision has thought about it pretty much over a long period of time. And I know we have the law in effect, I believe it's 20 weeks if I'm not mistaken, or what have you, about the viability and all at this point. So, I have some concerns about comparison with an operation, an elective surgery, versus that of someone that knows practically soon as it happens, and the thought pattern goes into play at that particular time.
And, yeah, thank you for those comments. I can understand some of what you brought up. I have not done a survey on this. What we're really focusing on is giving the mother the opportunity to review the information after she's had that first examination. So I think that you've got some valid points with, it's not something before the lady walks in the clinic that she hasn't already thought about this to some extent. So that is well founded. But we are simply going to asking to give this lady or these mothers the opportunity to consider that information they're given at the exam. Let them have 72 hours to look at that and think about it further.
I'd just like to comment also on that statement. We have a lot of intelligent females now, and we have the internet. And I'm sure that a lot of people access that and get information prior to them going to know for that particular service. So I just wanted to make a statement of that. Thank you.
Okay, Representative White?
To inquire.
Yes, proceed.
Representative Elmer, I appreciate Representative Kelly's comments. My concern, though, if you did just block, if you take the whole section out, is if we change 24 to 72 and that section becomes invalid, it does not. Your attempt is to revert it back to the 24-hour period, not to just say the entire section 2, for example, is gone. That would be my. I think the wording for what you're trying to get and what Representative Kelly's pointing at. I think you need to walk a fine line that you want to still have this 24-hour. If for some reason the court would not like the new 72-hour, we don't want the entire. We don't want 24-hour to go away too, and that would be nothing. We want at least that fallback 24 during the course of that restraining order. And so I have a little concern that I think that'd be some very good draft. Need to have some good drafting for that.
I can see that as well.
Yes, Representative Kelly.
As to the point, I don't think you get where you want to go by the language that's there now. I think you have to specifically say, if the 72-hour period is enjoined, you revert to a 24-hour period.
I agree.
So that would be even further. I mean, that would
Yeah,
be
don't get me wrong, I don't like any of this, but just from a legal point of view.
Better drafting, you're saying.
Yeah.
Representative Morris, did you have a question? I'm sorry.
Well, I was just going to say, I co-sponsored this bill with Representative Elmer. I just don't feel comfortable a lot of times making decisions for women, so I asked my wife, who's a nurse, and my advisor, and so I just wanted to say, despite the problems with the wording for the laws that we might have to try to make a change on, I still feel like that this is something that is so important. I can only go by 2 of my employees that I have working in my company since the last 38 years that have had a profound change in their life when they went through an abortion, and both of these 2 employees, really wish they had not had that done. So I just can't believe that just postponing this most important decision on life would would not be better if we didn't have a little bit more time for everyone to think about it. So that's why I co-sponsored it, that's why I thought it was important. I understand the legalities that we may have to work on, but extremely important decision, not just then, but it's, as these two employees that still work for me today, it's something that's affecting them every day for the rest of their lives. So I just appreciate that.
Thank you. Okay. Do we have anybody who would like to testify in favor of these two bills? Looks like you got a witness form, or proceed.
Mr. Chairman, members of the committee, Joe Artworth with the Missouri Family Policy Council. As the committee may know, in 1992, the Supreme Court issued the decision Planned Parenthood versus Casey. That decision remains, to this day, the key case that establishes the parameters of constitutional regulation of abortion in the respective states. In that case, the court had this to say: the decision to choose abortion is more than a philosophic exercise. Abortion is a unique act. It is an act fraught with consequences for others, for the woman who must live with the implications of her decision, for the spouse, family, and society which must confront the knowledge that these procedures exist, procedures that some deem nothing short of an act of violence against human life, and, depending on one's beliefs, for the life or potential life that is aborted. To promote the state interest in potential life throughout pregnancy, the state may take measures to ensure that the woman's choice is indeed informed. What the court proceeded to do in 1992 was to then uphold a series of provisions in Pennsylvania's laws that guaranteed informed consent, one of which was the concept of waiting period. And as the court analyzed the waiting period provision, it said the idea that important decisions will be more informed, deliberate, fully informed, if they follow some period of reflection, does not strike us as unreasonable, particularly where the statute directs that important information becomes the background of that decision. This General Assembly in 2010 did exactly that by enacting one of the most comprehensive informed consent statutes on the books in any state in this country, clearly delineating that the woman is going to be provided information about the nature of the procedure, the risks of the procedure, the alternatives she could consider. And the court affirmed that such a waiting period is a reasonable measure to implement the state's interest in protecting life of the unborn, and a measure that does not amount to an undue burden and thus is fully constitutional. The question of the spacing of the waiting period is a question that the court didn't deliberate on directly, other than to affirm Pennsylvania law. But I think what the court has said consistently since that time in succeeding decisions indicates that they do not believe a waiting period, even of 3 days, to be any kind of absolute obstacle to an abortion decision, does not hinder the decision, and ensures that it reflects a choice that is truly one that involves careful deliberation, consideration of the options, and the best interest of the woman and her child. Would be happy to answer any questions.
Any questions for this witness? Thank you.
Thank you.
I'm willing to do this if need be, time-wise, rotate people wanting to testify in favor with those who want to testify in opposition. We can do that. We'll go ahead and we'll do that. Is there anybody here to testify in opposition? We'll rotate it back and forth here, folks.
Good afternoon, Mr. Chair. My name is Jeffrey Mittman. I'm the director of the ACLU Missouri. I appreciate the opportunity to testify today in opposition to the bill.
Okay.
The ACLU Missouri has a mandate to protect the constitutional rights of all Missourians, whether guaranteed under the U.S. or Missouri constitutions. It is certainly understandable that the legislature wants to support a woman in making the complex decision about whether to start a family. However, the ACLU believes, and we work hard to ensure, that every woman has medically accurate, unbiased information so that she is able to make the best choice for herself, her circumstances, and her family without undue pressure. This bill is not about giving a woman time to consider her decision. Forcing a woman who needs an abortion to delay her procedure for non-medical reasons is dangerous and it's cruel. It's cruel to force a woman who has reached a very difficult decision after consulting her doctor, her family, and her faith to wait before she can get the procedure she needs. It's especially cruel when she is pregnant as a result of rape or incest, or needs to terminate pregnancy because she received a serious diagnosis that her health or the health of the fetus is in danger. In Missouri, a woman must already wait 24 hours after her first trip to the clinic when she receives counseling about all of her options, including carrying the pregnancy, adoption, and ending the pregnancy. Rather than allowing politics to interfere with a woman's most private medical decisions, we must trust each woman to make the best decision for her and for her family. Forcing a woman to wait at least 3 days in no way supports her decision making. These private healthcare decisions are best left to a woman, to her family, and to her doctor. Thank you. With that, I'll answer any questions.
Comments I'd like to make. I know Representative Elmer and Representative Doc Frederick have come together and Nate says, try to make an adjustment for 20, or offering an adjustment for 24 to 72 hours. Sometimes when you go in, a lady comes in and they've thought about this before they walked in the door, actually. But sometimes when they consult with a physician, sometimes there's information that they pick up that they're not familiar with. It's the same way when I was diagnosed with cancer. And I'm trying to understand where you're coming from, sir, when you're talking about cruelty. I don't see any cruelty when a doctor comes in there. Is he intimidating her?
Mr. Chair, thank you for the question. You raised a very important question, and absolutely there's nothing in law now that states that a woman may not have as much time as she wishes with certain, of course, medical restrictions. What this law does is mandates a uniform standard by law that has nothing to do with a woman's decision-making process or the medical decision process of the doctor by saying that it should not be 72 hours. We are not saying that no woman may have whatever time she wishes. So it's not as if one excludes the other. What this bill does is mandates a uniform standard that does not take into account that woman's process, her decision-making process, or the medical advice of her doctor. What it does instead is to restrict all women.
Okay, thank you. Representative Wood,
Dwyer,
thank you. Go, proceed.
just real quick. I think we had testimony from the two representatives that said that medical emergencies were excluded from the 72 hours. So would you please define need? Because you said when a woman needs an abortion, I can understand in a medical emergency where there would be a need for it. But otherwise, I know we get into word games in the legislature, but it would end up as a want. And a want, you could take the extra time without any fear of. So, but in your testimony, you use need. So would you please define that for me?
Certainly, thank you for the question, Representative. For example, let's presume a woman who consults with a doctor and the doctor has determined that the fetus has a medical condition which makes the fetus non-viable. However, that it is not a medical emergency such that continuing pregnancy would necessarily endanger her health or the immediate health of the fetus. In that situation, it is clear that woman needs an abortion. This is not a viable fetus. In that case, though, that is not taken into account as a medical emergency. And again, these are a function of a variety of situations. What this bill does is impose a single standard.
Okay, thank you. Representative Dr. Frederick?
To inquire.
Yes, proceed.
Are you an attorney?
I am strange as an attorney. I'm not a member of the Missouri Bar of Representatives.
Missouri attorney. Okay. Hey, I hope you can accept this in the spirit of the same way that attorneys can be in a case that is really hotly contested and they're really battering and doing their cross-examination. And then they walk outside the courtroom and say, hey, Bill, how's family? And you want to go get a beer, right? So I want to propose this concept to you. And I never took any philosophy classes. It was all science. But if you were to stipulate that the
baby were in fact an individual and a human, would it be, I mean, it would present a conundrum of monumental proportions for the ACLU and an individual attorney to decide who to advocate for. Have you given that any thought? I just mean that in the most sincerest way, that, well, if you did acknowledge that that was an individual, there's no way to, you'd have to have somebody else advocate for the child and somebody advocate for the mother, wouldn't you?
Representative, thank you for the question. Worse than being an attorney, I was a philosophy major as an undergraduate. So,
it's a perfect question.
And in point of fact, would love to have to agree with you. Did take it past this, and there's a famous article regarding the violinist situation, and we can discuss it at length. These are not simple issues. It is not black and white. These are clearly complex moral and legal and philosophical questions. However, given the law, and again, there's a review of the constitutional issues, given the competing interests, given what is going on, this is a complex medical, family, philosophical, and faith decision. In that case, we believe, the ACLU believes, that that decision is best left to the woman, her family, her faith guidance, and her doctors.
Thank you. Okay, moving on.
My name is Jenny Slossman,
everybody
and I'm a
interested?
registered nurse and a volunteer ultrasonographer at the Pregnancy Help Center here in Jefferson City. I've been a nurse for about 10 years. I've been volunteering in pregnancy resource centers for about 8 years. And I've been certified as a limited obstetrical ultrasonographer for 5 years doing ultrasounds in pregnancy resource centers. And I'd just like to share a few thoughts about my experiences seeing these women on the front lines. First of all, I think we can all agree that we would all like to empower and protect women, and I happen to feel that this bill, both of these bills, do that very well. We see a lot of women, certainly, who have been thinking about it for a lengthy amount of time. We also see a lot of women who have just found out they're pregnant and who come to our center in what I would describe as a state of panic, who are tearful and emotional, who have no idea what any of this medical information that they may or may not have received from an abortion clinic means. They might be what we would call in the medical world in a state of fight or flight. They are not thinking rationally. And I think that it would very much benefit these women to have a little bit of extra time to step back and look at this information with a calm and a cool head and truly consider all of their options. I've spoken with many women over the years who feel coerced or pressured to have an abortion, whether it's by a boyfriend who's threatening to dump her and kick her out on the street if she doesn't, by an abusive partner who's not giving her a choice. He's forcing her, he's driving her to the clinic, by a young woman whose parents are threatening to kick her out of the house if she doesn't have an abortion. Not all women who come to abortion clinics come there freely, and especially for those women who are being coerced or forced or brought against their will, 48 additional hours can mean a tremendous difference. Just one quick example, we had a young woman come to us not long ago for confirmation of pregnancy with her 5th child. She was newly homeless with her 4 children after fleeing a bad relationship, didn't have a car, didn't have a job, was just desperate, scared, and felt that abortion was her only option, despite verbalizing to us that she didn't believe in abortion. She didn't want an abortion because she had any other option. Everybody in her life was telling her that was all she could do. We presented her with other options, and she agreed to slow down and think about it for a few days. We got her a consultation with an adoption agency. We consulted with other agencies in our area that offer support to women, such as St. Raymond's Society for Emergency Housing, the Alternative to Abortions program through the state of Missouri for assistance with housing. She's now in a stable living environment with her 4 children. She's proceeding with an adoption plan for her unborn child, and most importantly, she was empowered and enabled to make the decision that was best for her and that she's at peace with and that she can live with, instead of being forced to do something she didn't agree with.
Okay, due to time limitations, we're going to kind of proceed with somebody to. Is there any questions for this witness? Okay, one thing comment I'd like to make, or just ask you briefly, You contribute about how many hours a week to this pregnancy center?
I volunteer 4 hours a week.
4 hours a week, okay, and you have others, you have a full staff of nurses that contribute, or what?
I am the only sonographer, so.
Okay, do you have physicians?
We do have a physician who is our medical director who reviews all of these scans, yes.
Okay, all right, good, thank you very much.
Thank you.
Is everybody testifying on, oh, I'm sorry, Representative Webb, or, I'm sorry. I just kidding. Proceed. I'm sorry.
He's not with us anymore.
I'm not. You're exactly right. I'm at lunch sometime.
Just a comment on your statement. It's been my experience over the years with different people who have contacted me with problems, just even within my family and things of that nature. Instead of reacting to it right now, unless it needs a reaction right now, is to wait overnight, or if it happens on Friday, to wait till Monday morning and see if you feel the same way. That's the comment I'd like to make, Mr. Chairman.
Thank you, Representative. Okay. Opposition, is there anybody who'd like to testify in opposition to these two bills?
Good afternoon. My name is Susan Gibson and I live in Jefferson City. Though I have given the issue of abortion careful and serious thought for over 30 years.
Ma'am, let me interrupt you just a minute. We have a limited amount of time. If you could kind of just make your points, please don't read to us. I would ask you just kind of make your points.
I'm nervous and I'm going to
I understand.
but I'm going to make eye contact with you. I was given less than 24 hours notice of this meeting, of this hearing, excuse me. I am opposed to an extended waiting period for abortion, yet I will give it 72 hours more, excluding the weekend, so that you and you and you and you can be convinced that I am capable of being certain about my decision regarding the testimony I will give. I will return on Monday for that purpose.
Thank you. Any questions? Thank you. Is there anybody testifying in favor of these two bills?
Thank you, Mr. Chairman, members of the committee. Samuel Lee with Campaign Life Missouri. I want to mention that the previous witness, the nurse, Jenny Slauson, these handouts that you've already received, they're from her center. So in case you're making the connection, one is the Pregnancy Health Center client testimonials. She talked about one of those, and then also just some literature here. And there's extras for others who are here today. And also, you should have written testimony from me about in support of both of these bills. I'm not going to read that. I would just say that there are two other states, as Representative Pace mentioned, two other states that do have a 72-hour waiting period, Utah and South Dakota, and those laws are in effect right now. And then lastly, I would mention in terms of, again, public support for a waiting period, a poll, the Marist poll that I mentioned in the previous testimony, that poll issued this month found that 79% of Americans support a wait of at least 24 hours. And more specifically, for the 3-day wait, the Rasmussen reports had a poll in 2011, around the time that South Dakota was ready to have their 72-hour waiting period law go into effect. And that particular poll found that 65% of Americans support a 3-day waiting period and counseling before an abortion, and that 65% believe the waiting period and counseling are at least somewhat likely to reduce the number of abortions. And lastly, Representative Pace, in trying to answer your question about surveys of women, in that particular Rasmussen poll, they, of course, divided up responses by men and women, and I'm just going to quote from that study, women are slightly more supportive than men of both the waiting period and sonogram measures. So at least based on that Rasmussen poll, women are even more in support than men are of this type of legislation.
Thank you. Okay. Representative Pace.
Just real quick, I just want to inquire, where was that poll taken? What areas was it in
Sure.
Missouri?
That poll was taken nationwide. It was at 1,000 adults. It was taken in March of 2011 by Rasmussen, which is a well-known pollster in this country.
So it was only 1,000.
It was 1,000 with margin of error plus or minus 3%. And Mr. Chairman, I'm happy to get that full report to you and to the committee members.
That would be fine. Thank you, sir. Okay. Is there anybody testifying in opposition? Yes, come forward, please.
Thank you. Thank you, committee members. I'm a lawyer, which probably means I didn't do enough math to ever get into medical school. But I didn't even have to consult my calculator to figure out that 24 hours is not the same thing as 72. And the Casey case, in fact, upheld a 24-hour waiting period. It was not, in fact, a more blanket waiting period. It was a specific provision of that statute. And actually, I find it a little telling that close to 30 states have 24-hour waiting periods and only 2, with among the most restrictive abortion laws in our country, have 72-hour waiting periods. And as to the South Dakota one, we do not have, in fact, any judicial opinion on the constitutionality of that provision. We have over 30 statutes in Missouri governing abortion care in this state, and a great many of them are couched in the language of informed consent requirements. It is our position at NARAL Pro-Choice Missouri that women, to follow up on Representative Pace's observation, women have the moral agency to make decisions. They have the rational capability to make decisions. And the Supreme Court has said that they have a fundamental constitutional right that is unique among other medically tinged or related rights to make the decision to terminate a pregnancy. I can understand motivations that some might have that may come from a solicitous place, but I would suggest to you that benevolent paternalism still is paternalism, and women have the capacity, the moral agency to make these choices. I recognize that different women might have very different reactions to an abortion at any time in their lives, but when we look at the scientific evidence, we know that the Centers for Disease Control looked at 13,000 women who said that the primary emotion they experienced after having had an abortion was in fact relief. And when you think about that, and you know that 61% of the women in this country who have abortions already are mothers, that may be illuminating for purposes of what that scientific study found. I sort of think Roe v. Wade, it gives us a trimester framework that strikes a reasonable compromise among the state's interest in the woman. Surely 2 trimesters is sufficient time for reflection.
I'm running out of time, ma'am. Just finish up there. Thank
We
you.
oppose this bill. Well, we oppose both of them. Thank you.
Thank you very much. Any questions for this witness, please? Okay. Next, anybody?
Members of the committee, for the record, Abram Messer with Missouri Family Network, Missouri Baptist Convention through the Christian Life Commission. We'd just like to go on record to support this legislation. You all have plenty of testimony.
Okay, are there any questions for this gentleman? Thank you. Anybody else who'd like to testify in opposition?
Reverend Rebecca Turner, Faith Aloud, we oppose.
Okay, thank you. Anybody testify in favor? Okay. Opposition? You're in favor? I'm sorry.
I'm in favor.
Okay, pardon me. Go ahead.
Joanna Schrader, I'm here as an individual, and as I said before, I have prayerfully witnessed outside Planned Parenthood in Columbia weekly for the last 5 years. And when they were doing abortions, they would have the women come on Monday for counseling, pre-op tests, etc., examinations, and then the abortion proceeded on Thursday. So they already had a practice of a 3-day wait. So, you know, why they oppose, you know, in putting that into law, it was already their practice. So I don't
You don't understand that?
Okay, thank you. Any questions for this witness? Okay, thank you. Anybody testify in opposition?
Hello, my name is Dina Vanderzalm. I'm also here to testify as a citizen. I am a resident of Columbia, Missouri. And I came here today, I took time off from my job and my studies because I feel so strongly about opposing both of these bills. I can assure you also this is not how I envisioned myself celebrating the 41st anniversary of the Roe v. Wade victory. I see this bill as an abuse of legislative power that is manipulating what is already a very sensitive and difficult situation. There seems to be no medical cause to delay a mandated 24 hours to 72, and it just seeks to push a woman further into her pregnancy and add additional logistical barriers. If I as a woman do not understand what is happening in my body, an additional few days is not enough for a semester of biology lessons to sink in and change my mind. Since this bill seems to have a fair amount of support from this committee, and it makes the assumption that women are not capable of making difficult decisions without the aid of politicians, requiring additional time, an additional 3 days to really think it through, then I can only assume that you're not going to legitimately listen or value the opinions that I would like to state today. Therefore, I would like to take your recommended waiting period and return Monday after I've had time to really think through my decisions. I'm pretty sure of how I feel. I'm pretty sure that's not going to change at all. But I would like for you to be able to trust in my opinions. So I'm fortunate that I have bosses, family, and friends that support me in my decisions and allow me the means to return. And I look forward to meeting with you on Monday to share my second testimony in opposition to these bills. This is a right and a privilege that many women in Missouri, hardworking Missourians and voters, cannot reasonably or feasibly do. So I'm happy to be able to come and speak on behalf of them, and I look forward to seeing you again. Thank you for your time.
Thank you. Any questions for this witness? Okay, thank you. Anybody testifying in favor?
My name is Leslie Kearns. I am Executive Director of the Pregnancy Help Center in Central Missouri. I would like to address the fact that the clients that we see, it's called a crisis pregnancy for a reason. They are in crisis. And when they're in crisis, they are not thinking straight. I've had women say to me, I can't think straight. I'm overwhelmed. They ask you to repeat what you're saying because they just can't comprehend what's going on. And even in this day of the internet, we have clients that come to us who do not understand what type of procedure they can have if they're so many weeks along, and that is new information to a lot of them, and so it takes them a while to process it, and we need to give them that time. And then in the center, it takes us time to contact the resources that are going to help them. I can't contact housing and find out if there's an opening in all the different areas, if that's what they need, or other financial support. So it takes time for me in the center to get the help for them that helps them make an informed decision. So we are empowering women by giving them all of the support that they can to help them make the right decision for themselves.
Okay. Thank you. Is there any brief questions? Due to time constraints, we're running very, very tight. Any questions for this witness? Okay. If there's anybody else who'd like to testify, we're going to ask for written testimony due to time limitations. Please submit your written testimony to this committee. And therefore, the time right now, we will have to adjourn this meeting. Thank you.